What I want to talk about here are the five major time limitations you are going to see on a criminal case in Louisiana. The first one we're going to talk about is what's called the first appearance. This is when you appear before a judge and you're told what your charges will be. In Louisiana, you have to be presented to a judge within 48 hours for the judge to see that there's probable cause for your arrest. Also, there's a 72-hour limitation where the judge has to have you appoint a counsel if you're entitled to it. Generally speaking, those two proceedings are combined at one at that first 48 hours, and that is also where bail is set. The second thing you want to look at is what's called a 701 motion, and this is, in essence, the time it takes for the district attorney following arrest to file charges to still keep you on your bond obligation. The time limits will depend on whether or not you're charged with a felony or a misdemeanor, whether or not you are charged, or whether or not you are in jail or on bond. The state has less time to file charges if you're in jail than on bond, and they have less time to file charges if you're on misdemeanor as opposed to a felony. So the time limits are 45 days for jailed misdemeanors, 60 days for jailed felons, 90 days for bonded misdemeanors, 150 days for bonded felons, and 120 days if the charge is for a life or death crime. What happens if the state doesn't file charges within those time periods? Well, you're relieved of your bond obligation. As a practical matter, that means someone that's in jail can be released from jail. Someone that has special conditions, other bond supervision, like taking weekly drug tests, having a report to a probation officer, will be relieved of those opportunities. Now, that doesn't kill the case. The state can still charge you. There's other statutes of limitations applicable, but generally speaking, the law does not want you to rot in jail while the DA makes up his mind. The next time limitation I want to talk to is really your statute of limitations, or the times to institute prosecution. There is absolutely no time limit placed upon the state to arrest you for anything that requires either a life or death sentence, and now with recent laws, forcible or second-degree rape. So those can be prosecuted whenever. You can be arrested 30 years from now, 40 years from now for a crime and be prosecuted. Now, there are certain sex crimes involving minors. Those have a 30-year statute of limitations, okay? And that's really based on having a minor become a fully functioning adult, then coming and making the charges. Outside of those two extremes, the law places very, very strict time limitations on instituting a case. It's going to be 6 years for second-class felonies, which would be any case that requires hard labor, i.e. drug distributions, armed robbery, aggravated kidnapping, anything that requires hard labor. The state has 6 years to institute a case. Third-class felonies, those are things with or without hard labor, they have 4 years. This would be drug possession, car burglary. Minor felonies will have a 4-year statute of limitations. So what does that mean? I write a bad check today, 6 years from now I can't be prosecuted for it. Misdemeanors that have a potential jail sentence have a 2-year statute of limitation. So I get arrested for a DWI today. The state has 2 years to file charges. 2.5 years go by, I cannot be prosecuted as a matter of law, even though I can be as guilty as sin. And then for misdemeanors that are just fine only, there's a 6-month time to institute charges. Now, the next category is dealing with the time it takes to bring somebody to trial. This is going to be very, very small. So for misdemeanors, the state has 1 year to bring you to trial. For felonies that do not require life or death as a penalty, they have 2 years to bring you to trial. And for first-class felonies, things that require a life or death sentence, they have 3 years to bring you to trial. Now, you should know that that time limitation is suspended while the defense litigates pretrial motions, but there are some pretty strict time limitations placed on the state that if they do not bring you to trial, the case is over with. The last thing I want to talk about is what's called your speedy trial. And this is, in essence, the defendant and the defense attorney filing a motion in the court saying we are ready for trial. It has to be signed off under oath that you're ready by the attorney and the defendant. Once that's done, the state has 120 days to prosecute a felony of someone that's in jail and 180 days to prosecute someone that's in jail or on bond for a felony. Okay, so those are the 6 common time limitations every person who's going through this criminal justice system needs to know about. Any questions, you can email me or call me at 927-1234. Thank you.